Hello, and welcome to our Stepping Stones podcast, supporting Americans with each step of their unique journey in the UK. I'm your host for today, Scott Barber, partner at Buzzacott, and I'm joined by
George Mitchell, a partner at Forsters in the private client team.
Lucy, an associate at Forsters, also in the private client team.
Martin Scullion, Buzzacott, partner.
In this episode, we'll discuss moving to the UK, and to get started, let's share the story of our client, Bill. Bill is a U.S. citizen with a love of travel, and a career drive has led him to plan a move to the UK. He has asked his employer about the possibility of relocating on a secondment, and so is looking into a UK work visa. If that is not an option, Bill will become an entrepreneur and set up his own company. In either case, Bill is seeking advice on his immigration and personal tax, as he's been made aware of the complexities of expatriate tax and benefits of planning ahead by his friends already in the UK. So, step one, applying for a visa. Lucy, what are the visa options available for someone moving to the UK on a secondment from an existing employer?
Well, I think the first point to note is that Bill may not initially be aware that he needs a visa. A lot of US citizens are under the misconception that they can work and live in the UK freely, and that's because they can travel here for up to 6 months at a time without a visa. So it's really important that he's made fully aware that he cannot use that to work in the UK. And we've actually been seeing some clients be told at the UK border that they're overusing that exemption and they could risk being turned away. So first step, make sure he gets one. And the first option for him, if he's planning to work in the UK, is the skilled work visa. At Forsters, we don't tend to advise directly on these because our focus is advice on for high net worth individuals. And what tends to happen in this situation is the employer will manage the work visa for the employee. But I'll cover it in broad terms because it is something that clients ask about. So broadly, the employer would need to apply to the Home Office to become a sponsor. Bill would need to be working in an eligible occupation, so those tend to be more skilled managerial positions or above. And he would need to meet a minimum salary requirement, and that is set by the government. And this is a good option if Bill is going to be working. It would be granted for 5 years, and he could really come and go freely. But the downside is that it really is contingent on his employment. So if he wanted to move jobs later down the line, he would need to move to another sponsoring employer, and that can be quite challenging. And certainly with the coronavirus pandemic, we've seen clients become quite concerned about the stability of their jobs with redundancies and things. So this would be a good option if he's really confident and secure in his job long term. But if he thinks that that might not be the case, he could consider some other options, I think.
Okay. And if the employment is not an option, what avenues might be available if Bill wants to come to the UK and perhaps set up his own company as an alternative to an employment arrangement?
Yeah, so as an entrepreneur, he's got a couple of options. So the first one is what's known as the startup visa. And that's really for individuals who aren't yet experienced in setting up their own business. They're really starting out and want to do so in the UK. The alternative, if he's more experienced, is the innovator visa. And the broad requirements for these are quite similar. So Bill would need to have an endorsing body support his business. He would need to show that it's innovative, viable and scalable. And then that endorsing body would sort of support his application. One of the practical considerations of that is that they may want some kind of stake in his business, so some kind of economic rights going forward, and that might not be appealing to him. But if he's comfortable with that, that's an option. And the startup visa would be granted for 2 years, and that can't be renewed. So it's really a stepping stone into the UK. Whereas the innovator visa, that's a 3-year term, and he could continue to renew that. So if he was continuing to grow his business and just wanted to stay in the UK to do so, he could continue to renew every 3 years. And ultimately, he's got options for indefinite leave to remain down the line, which I think we're going to talk about a bit later.
Okay. And finally, if neither of those two options is appealing, either in employment or being active in his own business, I understand there are various types of investor visas that he might apply for. What are the criteria for those types of visas?
Yeah, so the investor visa is something that we advise on most commonly. It tends to be really appropriate for a lot of clients who have sufficient funds available. So Bill would need at least £2 million. And he'd need to have had that in his control, and he would need to put it in a regulated bank in the UK. And he'd need to do that before he applies for his visa. And essentially, if he has those funds available and he opens that account, he will qualify for the investor visa, which would be granted for just under 3.5 years. And it's a really good option because he can work in the UK. For most jobs, there are a couple of odd exceptions, so he can't be a doctor, dentist or sports person, but assuming none of those apply, he can work freely, he can come and go as he pleases, he can study if he wants. There's no restrictions on employment or setting up his own business if he did want to do that. And once he's coming towards the end of that initial term, he can also apply to extend his visa. So he would need to show that he'd invested that 2 million, at least 2 million, into qualifying investments. So broadly, that's stocks or loan into UK trading companies, so active trading companies. And as long as he's done that and maintained that for 2 years, for the full period of his visa, he can then extend for 2 years. And he can continue to make that extension indefinitely. So he's got the option to apply for indefinite leave to remain in future, but if he just wants that freedom, he can just keep renewing his visa, and that gives him a lot of flexibility.
Okay, very good. And finally, with all of these options, I think people are always surprised at how long these things can take. What sort of time frame would you normally recommend that people look to have the visa in place before they arrange to move here, and what's the quickest they can do it?
So I would say the bare minimum that you really want is 3 months. And there are options for sort of fast tracking the visa being granted. So for all of these, the applicant would need to attend a biometrics appointment. So that's fingerprints, facial recognition, photographs, all of that. And for some visas, you can get a decision within 5 working days from that appointment. But it's not always available, and especially with the coronavirus pandemic, that option has been curtailed in a lot of cases. So I would always say the earlier the better. And especially for the initial visas, I think clients often underestimate the documents they need to get in place and how long that can take. So things like setting up a bank account as someone who's not in the UK with a UK entity, sort of establishment, that can take some time, especially if they don't have an existing relationship. And with some visas, so for example, the spouse visa, which we haven't touched on, but it's one where you would need an overseas criminal record check as well. And that depends on each country. So that can take some time. So I would really say the longer the better. 6 months is a good ballpark.
Right.
If you came to us at 3, we could help. But please try not to leave it any later than that.
Okay, thank you very much. One of the things Bill will need to be aware of as a U.S. citizen is that all U.S. citizens are subject to worldwide tax, regardless of where in the world they are resident. So potentially, at the same time, he'll be subject to U.S. tax rules, but when he moves to the U.K., he'll also be subject to U.K. tax rules, and of course, this can get very, very complex. So, Martin, what is your experience with that transition and the complexities that brings?
Ideally, it's Bill should get advice before he actually moves over to the UK. So it's not always the case that this happens, but for tax planning reasons, it's always useful for him to get advice before he actually moves. And most Americans, I think, are aware of their continued US obligation. I think, probably from an education perspective, I imagine that they're told, I don't know what your experience with that, Scott, is, but I imagine they're told that you have to file just for being a citizen. But when they move to the UK, you're looking at federal advice, UK tax advice, and potentially some state tax advice. Depends on what state they're moving from, and it's important for them to understand, when they come to the UK, when do they become UK resident, but do they actually break residence in the state they're moving from? And that can depend on whether they still have a footprint in that state, so potentially a property or something like that, where they still have their belongings and they still live in when they're back in that jurisdiction. So, I'm thinking of places like New York, for example, where you might continue to have residence there because of your property and your ties to New York. So getting the right advice before you actually move. How do you break New York residence or state residence before you move to the UK can be important, because if you're UK resident and state resident, you're paying extra tax that you might otherwise not incur. But yeah, so it's you're looking at your ties back to the home jurisdiction, but you're also looking at whether when you become UK resident, you've got the UK statutory residence test, which we can advise on, and we can determine, are you going to be resident in that tax year, or is it going to be the next tax year, or non-resident, or are you going to be part year resident? There's split year rules that we need to consider as well. And this can be important because once you understand when your resident date in the UK is, the planning kind of needs to happen before then. We can discuss that in a bit later after we go through domicile.
Yeah, absolutely. And I think, again, we'll spend a lot of this series talking about the federal rules because that is, the more expensive tax and so forth. But you're quite right that people need to appreciate that where they're coming from in the U.S. matters very much. It's quite straightforward if you're from Florida or Texas. These are states that don't happen to have an income tax regime. It's reasonably complex if you're from one of the northeastern states, I would say in particular, and also California. So that's a piece that mustn't be overlooked. And Martin, as you indicated, it's also quite relevant what their plans are in terms of retaining property in those states in terms of a home, and whether or not the family is moving with the individual. That can have a major impact on the outcomes. And of course, the worst outcome from our standpoint, if someone winds up being resident both in the UK and in the state they came from, they could wind up with quite a higher combined rate of tax. You've mentioned there a domicile and its importance to tax here in the UK in particular. George, I wonder if you might just guide us through that, and perhaps also bear in mind that what an American might think of as a domicile is perhaps a different concept from what the UK thinks of as domicile.
Sure. So if I just start with the UK concept of domicile, it's another factor like residence which determines an individual's tax treatment. And it can be relevant for income tax, capital gains tax that we have over in the UK, and inheritance tax. And it is a little bit different from the US concept, but there is some similarity in the sense that with the UK one, what we're really thinking about is where someone intends to remain permanently. So where's their ultimate home going to be? And everyone starts off with a domicile of origin, and typically that's the father's one. And it's worth bearing in mind, as with the US, domicile is linked in a federal system to a particular state, so that could be New York or California or something. And over here, it would be England. And then layered on top of that, if someone moves to the UK and they decide, hopefully after a little bit of time and after they've obtained some advice, that actually they do ultimately want to just stay here, then they could acquire what's known as a domicile of choice. And that can have some repercussions tax-wise. And then on top of that, so that's the sort of general law principle of domicile. And then on top of that, we have a tax rule as well, which deems someone to be domiciled in the UK if they've been resident here for at least 15 out of the last 20 tax years. And that then means, it's a bit like acquiring a domicile of choice over here. It then means that they're fully exposed to UK tax across the board once they're deemed domiciled. So the reason we think about someone's domicile position, if we step back a little bit, and as Martin will come on to, is if we're thinking about their income and capital gains tax position just from a UK perspective, then if they're able to say that they're non-domiciled in the UK, and this is before they've been here for 15 tax years, then they can claim the remittance basis. And that is a regime which allows someone to pay tax only by reference to their income and capital gains that arise in the UK. And as long as they don't remit, so bring in income and gains that come to them outside the UK, then they won't pay tax on that, at least for the first 7 tax years. So that can be relevant for a US citizen if they're thinking for the first 7 years, actually, do I want to keep my compliance possibly a little bit simpler and leave my non-UK income and gains outside the UK, claim the remittance basis, and not have to disclose all of this information about those income and gains to HMRC. It's not quite like the IRS, but some people may not want to disclose everything to HMRC. And there are also certain types of investments, like municipal bonds and US mutual funds, that don't have reporting status, where actually claiming the remittance basis means that you're not paying the higher of the effective tax rates, because the UK taxes both of those sorts of investments at a higher rate than the US does. So it's those sort of differences where claiming the remittance basis may be advantageous. And we'll come on to, possibly later on in the podcast, talking about some of the inheritance tax implications of domicile, and thinking about when someone's moving over to the UK, if we just touch on the basic premise that if you're non-domiciled, then generally you are only subject to inheritance tax on assets located in the UK. But if you're staying in the UK, you might want to think about putting some of your assets in a trust to protect them from inheritance tax. So those are some of the considerations for domicile.
And just on that, before we leave the subject of trusts, obviously trusts are used extensively in both jurisdictions, but I think Americans tend to be surprised at how highly formalized trusts are still regarded in the UK, and perhaps we're used to using grantor trust as virtual piggy banks.
Yes.
What have you seen in that space, and what is it that Americans need to understand about any trust that they already have before coming to the UK, what that trust does for them, and who the trustees of that trust might be?
Yes. Well, if they're thinking about moving to the UK, then you're absolutely right. We would want to see what trusts they already have in place. So, as you're saying, individuals quite often have revocable grantor trusts set up as a piggy bank to hold assets rather than necessarily leaving everything to fall under their US will, because I understand probate in the US isn't the easiest and takes a bit of time. So you quite often have a revocable grantor trust as that piggy bank. But then we have to think about, well, how's that trust, as you're suggesting, going to be treated over here? And there are two ways which it can be regarded. So it can be seen as a bare trust, so a nominee arrangement, transparent for the individual. It's effectively a bit like what you're saying, a piggy bank. It's just their assets and they're taxed on the income and gains as they arise. The alternative is that it may be seen as a proper trust, so a settlement over here. And those two options have very different tax treatments here. So it's critical that we review the trust.
And Martin, along the same lines of things that people should do or timeframes that are helpful for them, we talked a bit about domicile and the remittance basis. In terms of the remittance basis and what income is not subject to tax in the UK, can you walk us through the management side of that? Because people have to appreciate once that income has escaped tax for the tax year involved, they don't then want to subsequently somehow bring that money into the UK. And it's very important to understand it. We don't have any similar concept to this in the US, that once an item of income or gain goes into an account, the HMRC actually has a methodology that says we can look at the account and tell you where everything came from. And depending on what you do with it, if you bring that money to the UK, even 5 years later, at that point, it becomes subject to tax and you could wind up with a double tax charge. How do you manage that? And maybe it's useful for people to understand in terms of bringing money to the UK if they want to, there actually will never be a better time to bring money to the UK than in the time period before they actually become resident here.
Yes, so it's important right at the outset to understand that the best time to remit the money is before you've actually become resident, because you've not actually by that point generated any income in the US that would be taxable. So everything at that point of day one when you move to the UK will be what we call clean capital. So it's important to know that if there's money required in the UK over your period that you're here, that point is a good point to bring the money into the UK. In terms of managing going forward, if you want to remit in the future, you need to preserve any clean capital you have. So any money that you've generated pre-residence is clean capital. So setting up bank accounts that preserve that and don't taint that money will be important. It's sometimes difficult to achieve that with US banks because the segregation of income and gains, it's hard for them to understand the concept of UK taxation and remittances. So it's not always done properly in the US. So you may want to, if you're looking to manage it properly, look at offshore accounts in places like the Jersey and Guernsey, which are in the UK banking system, but it's not a remittance if it goes into a Jersey or Guernsey bank account. But they would be able to manage and segregate income gains and clean capital so that you're able to preserve that clean capital when you need it to prevent the income and gains being remitted and being taxable. The other thing I'd mention for Americans is that obviously you're still taxed in the US on the income and gains, so the remittance base is an option. You don't need to claim the remittance basis. It's a year by year decision, and in certain cases it might be some Americans might be on the arising basis and be taxed in the UK on worldwide income, and the use of foreign tax credits in that situation, making sure that the UK tax is paid in the same year that the income is generated so that it can offset the US tax. That's quite important. So it depends on the client situation and how much they need in the UK, how much income they generate offshore. So it's a discussion you have with every client, and it's all can be different outcome each time.
Yeah, and I think Martin's really clearly covered the importance of maintaining that clean capital, and that's actually really important for the immigration advisors to bear in mind as well. I mentioned that the investor visa is often the most appropriate choice for many clients. And as I said, that will require at least £2 million to be brought into the UK. So it's really important that ideally that's brought in before the individual becomes a UK tax resident, to avoid any possible remittances, or failing that it's funded with clean capital. So it's just highlighting how important it is for the immigration advisors and the tax advisors to be aligned on that.
Yeah, and I think it's important to say as well, in terms of tax residence, there are some fairly bright line rules around what makes you resident in the UK. It's largely driven by your days of presence in the UK, combined with factors such as, do you have family who is also resident? Do you have a property available to you? Do you have an employment in the UK? But it's important for people moving to the UK to understand as well that if they've spent significant time in the UK in the last couple of years, the calculation is cumulative. So if they've been here for other purposes, even if they weren't necessarily even thinking of being resident, that those days might tally against the date at which they're deemed to be resident for UK purposes, and that's something that's very important in a lot of these tests and how you're treated for tax purposes in the UK. A key consideration is always, when did they become resident, and that's something that you'll want to understand if you're planning to come to the UK, is when will you become resident, and when will you break residence with perhaps the state you're moving from. And those are all very important considerations, because you don't want to leave that decision up to the mercy of what a tax investigator thinks. They will want you to be resident from the earliest possible moment so they can start taxing you. George, before we move on from the pre-planning side of things, are there any legal issues that Americans moving to the UK ought to think about and get advice on?
So, Bill, we've talked about the possibility that Bill is an employee. So he may want to get his employment contract. We don't know whether he's going to continue to be employed by the US entity, or he's moving to a contract with a UK subsidiary or something. So he may want to get his contract reviewed. And if he's going on secondment, it's especially important for him to think about, well, does my contract allow me to go back to the role that I'm coming from in the US? So there's those sort of considerations, and our employment lawyers can help with those. And just touching on one other thing that he may want to think about, if he's holding property through an LLC, or he's got interests in an LLC, the UK and US do treat LLCs differently for tax purposes. So quite often LLCs are transparent in the US, whereas HMRC at least regard them as being effectively companies over here, so opaque. And if he's receiving income from an LLC, that may be something he wants to have a word with us about, if there's anything he can do on that front.
Just moving beyond that, and we mentioned earlier about the difficulties of setting up a bank account. I think we also see a similar issue when people are moving to the UK, not necessarily in terms of buying, but in terms of just renting a property, renting a flat perhaps, or renting a house, that A, they don't have a bank account, and B, they don't have much of a credit history. Is that something you've seen in practice, and how do clients sort of work around those issues when they first come to the UK?
So I think if it's difficulties with credit, sometimes it's saying to the landlord, okay, maybe I don't have this credit history that you want, but I'm willing to pay 6 months, say, or have many months of rent upfront.
Yeah.
I've got the cash to do it, so I'll just pay that. So there are ways around that, possibly.
So step 3 is really arriving in the UK, and I think at this stage it would be helpful to just think about some of the wider implications perhaps for Bill's family. So this is the phase at which kids will be starting in new schools depending on where they live. It might be an international school, or they perhaps will go to a school in the UK that's a UK-based school. But that's obviously a big shift. But Lucy, what about the basic issue? We've talked a lot about the visas for Bill as either an employee, an entrepreneur, or an investor. But what impact does that have potentially on a spouse and on minor children? What's the basis of their right to live in the UK?
So with the visas we've discussed, it's possible for Bill to bring in a spouse or a long-term partner and any minor children as his dependents. For some of the visas, there are a few additional requirements, but they tend not to be too onerous. And really, he is free to do that. The only thing to bear in mind, and we'll kind of go on to this a bit later, I believe, is that if his family also want to end up staying in the UK, they will need to meet the residence requirements for applying for definite leave to remain and potentially citizenship as well. So we mentioned schooling. If, for example, he were to arrive in the UK with a child ahead of time to start school, but his spouse were to join later, to tie up perhaps things in the US, it's just important to bear in mind that they then might have differing day counts, and that could be something that had to be considered later down the line if he decided to stay.
Yeah, and I think that's a really important administrative point that someone moving to the UK will want to be aware of. For various reasons, both tax but also the visas, they will regularly be asked about the number of days they spent in the UK, the number of days they spent perhaps in the US, and even within individual states within the US perhaps, but also foreign time that they spend, whether on work or holiday. So they will want to come up with some sort of system for demonstrating where they've been basically 365 days out of the year. And I understand, Lucy, this question comes up again when they come to apply to renew visas or extend them. What's that process like?
Exactly. So if we take the initial visa in the first instance, that can be particularly challenging because for some cases, so for example, George and I had a client who was actually applying for a spouse visa, but it was a US client, and he needed to be able to explain his travelled for the last 10 years, and that is not something that people habitually keep track of. So there's a bit of flexibility in sort of doing your best about collating that information, but any records are really appreciated. And going forwards, like you said, once that visa is granted, in terms of later down the line applying for definite leave to remain or citizenship, you have to show basically exactly where you've been, whether that's in the UK or outside the UK, for every single day of that period. And that can be quite challenging. So when we're advising clients, we always will give them essentially a spreadsheet that they can fill in, and that will keep track of their days for them, especially because these absences are calculated on a rolling basis. So it used to be a bit easier, sort of you count every single 12-month period from when your visa is granted and make sure you're not out of the UK for a set number of days in that period. But now it's any 12-month period, so you have to sort of redo the calculation every day going back 12 months, which, like you said, is quite tricky. So what I would say is use technology to your advantage. Most people buy their sort of travel tickets online. You know, keep a subfolder in your emails, just something where you know exactly where all that is. We can do the hard work for the client. We're happy to sift through that and put that together, but it's just important that they are generally aware of the importance of keeping track and being aware of where they are during that period.
Yeah. And I think it's interesting in a lot of ways, when you come to the UK, and I moved to the UK more than 20 years ago now, there's a lot about your sort of financial and administrative life you've got to do over again. We've talked about setting up bank accounts, finding a property to rent. But there's also things, if you're staying longer term and you want to be able to drive, I mean, it's beyond the scope of this discussion, but at some point, if you stay in the UK, I think longer than a year, and you want to be able to drive here, you have to go sit a UK driving test, which I've got to tell you, folks, is a lot more rigorous than most driving tests in the U.S. And you've got to get used to driving on the wrong side of the road, which takes a while. Martin, just extending that, obviously on the tax side, what are some basics that people should know about Her Majesty's Revenue and Customs, which in the UK is the equivalent of the IRS? What do they have to do to register with them, and what's the interaction going to be like?
Yeah, I mean, most of the time if Bill was to become resident in the UK, he's going to have to register to file under what's called self-assessment, to file a tax return in the UK. So we'll be able to get them registered, and we can help them prepare a UK tax return. It should be relatively straightforward if they're on the remittance basis and they're not remitting overseas income to the UK, and then perhaps they have just UK sourced income from employment, self-employment, that sort of thing. To begin with, I mean, they might end up with investments in the UK that they have to report. Particularly if they've got an investor visa, there might be some income generated from that. But that should be relatively straightforward, and it'll be mainly the main thing that we're looking at is making sure that any UK tax is paid in the year that the income is earned, which is usually straightforward for employed individuals because the tax comes off the pay slip and it's withheld. Whereas for self-employed, the onus is on you to pay your tax at the end of the tax year, and then potentially pay payments on account, which are the equivalent of estimated payments and for the following tax year. And I guess the one issue with self-employed is, you might have to consider making an upfront tax payment in the calendar year that you're resident in the UK to ensure that there's no double taxation, because the US work on a paid basis for foreign tax credit purposes. The paid basis works for UK residents. There is an accrued basis, but that doesn't normally work well for UK residents. So you look at any tax paid in the year can be offset on the US tax returns. So for self-employed individuals, it's usually important to pay in advance. So that's one thing. The tax year end in the UK is the 5th of April, so you need to get used to, the US being a calendar year, a bit of a difference in the information that you need to collect. But that will really be an issue once you're on the arising basis. If you're on a remittance basis, it's only UK source income, so the statements you get are going to be UK tax year. Whereas if you start having to report all your US investment income in the UK, it gets a bit more tricky gathering information to be able to prepare a tax return. But yeah, it becomes more complicated once you're on the arising basis. There's potential planning before you go onto the arising basis that you will probably want to have.
I think another area that's worth discussing is, George, when someone moves to the UK and they're going to be resident here for a period of time, in terms of legal documents, we've talked a lot about trust, but what about something as basic as their will? Do they need a new will if they're coming to the UK? What do you see in that space?
Yes, that's a good question. I think it depends, as with anything, on the facts. But if we were talking about Bill buying a UK residential property, so if he owns, that's obviously located over here, and just thinking about the ease of dealing with probate, so the administrators dealing with his estate once he's passed on, then actually having a UK will that deals with his assets located over here is going to help with that. And the reason for that is if we rely on a US will, then we'll need an affidavit about foreign law, so we'll have to go off to a US attorney to get that, which of course we can do, but it adds to the costs and time that it takes to deal with his estate. And the alternative, if you use the US will as the primary document and apply for probate in the States is you can get a court exemplified copy of that US will, and then we understand that the UK probate registry typically will accept that. But again, that's a timing consideration because of the timing it takes in the States, I understand, to get probate. So that's a good reason to have a UK will which deals with your UK property over here. And when we're thinking about wills, broadly, what we're trying to do is make the most of the exemptions in both jurisdictions, and also make sure that we're deferring, to the extent possible, tax in either jurisdiction until the second death. So if Bill is married or in a civil partnership, then we're trying to get the tax event to occur on the second death, so that we can use the first death. We can do some planning after that to try and reduce the ultimate tax bill.
Yeah, and I think it's important to understand that if Bill is not domiciled in the UK, he in terms of a UK estate problem, he sort of broadly has 15 years before he becomes, as we call it, deemed domiciled in the UK. So really, at least in the early stages, it's potentially just his real estate and perhaps some other UK assets that are in the UK net. But that can be planned for. But again, he'll want to take advice in early stages to see what he needs to do to make sure that that's implemented correctly. Just to discuss the final step, which is staying in the UK longer term. I have to say my experience, and Martin, I think our experience of most of our clients, is I certainly came to the UK expecting to be here for 2 or 3 years, and 23 years later, I'm still here. And I think most of our clients would tell a similar story. Most people come here for a specific purpose, perhaps related to employment, related to family, perhaps related to education, and then something happens that causes them to stay. So, Lucy, in that circumstance where someone comes here and they've had a visa of any sort that perhaps allowed them to come initially for 2 or 3 years, we've discussed they can renew it, but what if someone gets to the point of saying, I'm staying and I really don't know when I'm leaving. In fact, I may stay very long term. What are their options then?
Yeah, so that's the perfect time to consider indefinite leave to remain, or ILR, and more commonly known as permanent residency. That's how we see clients refer to it. And broadly speaking, Bill would be able to apply for this after he'd been resident for 5 years under one of the other visas, or a combination of them. And he would need to meet the absence requirements. So I touched on those earlier, that in sort of any 12-month period, he will have need to be not absent from the UK for more than 180 days. So if he meets that and the specific terms of the visa he's on, so that will vary slightly depending on which one he's in the UK on, he can then apply for indefinite leave to remain. And broadly speaking, that means he can stay in the UK indefinitely, move about freely, and he can retain that status as long as he's not absent from the UK for 2 years. So he can keep that on an ongoing basis. And then if he decides to make a more permanent step, he can then apply for British citizenship. So generally speaking, he'll have needed to have held ILR for 12 months and can then apply for citizenship. And there are, again, some more absence requirements. One of the sort of key ones to bear in mind is that he will have needed to not be absent from the UK for more than 90 days in that last 12-month period. There are exceptions, so we've had some clients who've been able to have a bit more flexibility because of COVID. They haven't been able to be here for that entire period, but generally 90 days is your cap for being out of the country. And then if those sort of requirements are met, Bill can become a naturalised British citizen. And there are sort of tax implications of that. They're not completely linear. So unlike in the US, citizenship isn't an automatic connecting factor for tax purposes. So Bill can become a UK citizen and still be non-domiciled and sort of have that flexibility. But there has been sort of a shift in Home Office guidance. So it's long established in case law that citizenship is a connecting factor for domicile. So George mentioned domicile of choice. Acquiring citizenship here would be one sort of indicating factor that he had acquired that. But the Home Office has actually gone a bit further, and their guidance to their caseworkers now says that if Bill were to apply for citizenship, he would need to confirm that he intends to have a home here, his principal home here in the UK. And that's not exactly the same as a permanent home for domicile, but the Home Office does seem to be aligning those concepts. So they've sort of asserted in their guidance that if an individual is continuing to claim non-domiciled status, that might be grounds to refuse a citizenship application. And conversely, if they're granted citizenship, HMRC may be more inclined to make an inquiry into Bill's domicile position on the basis that he has citizenship. So this is just guidance. It can't change the common law position that citizenship is just one connecting factor, but it's a trend sort of moving towards being a bit firmer on that from the government's perspective. So it's something that Bill should be made aware of if he does want to go down the citizenship route.
And as a practical matter, though, as the UK has also on the tax side changed its rules to bring in the deemed domicile concept, how interested are they going to be on the basis that if you have a time frame that you become domiciled for tax purposes, that's 15 years is it's a long time in some ways and not very long in others. Is it something that we see them looking at particularly intensively?
So we haven't seen that much in practice yet, but I mean, one thing to bear in mind is that you could become a British citizen within generally around 6 years if you wanted to. Mm-hmm. And that's obviously, you've still got a long time then before you become deemed domiciled. So if, for example, you were to do some planning in that sort of second half of that time period, and that was for a particularly wealthy client, that might raise some questions with HMRC. So one practical step is actually to consider making any plans along those lines before acquiring citizenship.
Yeah, I think it's one of these things that it's because it's based on court cases and facts and circumstances around various court cases over the years. There's no statutory test on domicile, so you kind of you just need to sort of build up a file of your connection back to the US in this situation, and to show that your intention is not to be in the UK permanently or indefinitely, which I think is one of the issues of becoming factors of becoming UK domiciled under by choice. So I think it's having a domicile review and having sort of a file with all your connections to the US is probably quite important before you set up any excluded property trust.
So as our final step for this morning, can each of you just say a few words on the sort of professional advice that someone like Bill should seek, and how your firm can help them?
Yes, so at Forsters we would help, as we've sort of covered in this podcast, with Bill's estate plan and succession plan from a UK perspective, and there we're trying to navigate the tax rules in the UK and the US. So we're English qualified lawyers, and we can help on the UK side of things, but we're familiar with the US aspects from advising on these sort of things for a number of years, and we would work together with a US attorney to help set up an estate plan, and we would also work with someone like Martin on the US-UK tax side of things as well. And then Lucy's part of our US-UK Connections team. So in addition to your immigration advice, Lucy, you would also help me and other members of the team with the sort of bills, wills, and various trusts and those sort of things. So,
yeah, absolutely. And then on the immigration side, it really is just helping Bill through that process. There are a lot of very specific requirements, and the Home Office is very particular about how those requirements are met. And it can be quite challenging to meet those, even in a professional context. So for an individual to try and do it without advice really would be very challenging. And then again, just as he wants to maintain his status, pointing out those sort of things that he's got to meet throughout the process, absences, any particular sort of tick boxes that he needs to meet throughout, so that if he ultimately wants to stay in the UK in the longer term, he's really best placed to do that.
Well, at Buzzicott we can help clients like Bill because we're dual qualified US, UK tax advisors, so we can give joined up advice before he comes here and once he's here, because it depends on what happens once he gets here and how his plans go ahead. We also prepare US and UK tax returns, so we can help him with that. It's, I guess, take a lot of the pain away of trying to do it yourself, or I guess in some cases some people use two different, a US advisor and a UK advisor to do the tax returns, and sometimes it's not the most smoothest process if you're dealing with two advisors, but we can do it all here at Buzzicott.
Thanks to our speakers for joining us today, and thank you for tuning in. Plan your next step by taking a look at the other episodes in this podcast series covering the topics of business, property, children, and more. Thank you.
Thank you.
This Stepping Stones podcast is brought to you by Buzzicott, a top 20 UK accountancy firm based in London with a team in Hong Kong specialising in US and UK tax, financial planning, corporate business services and audit.